Hi, welcome back. In this topic, we take up another means of dispute resolution. This is a private means of resolving disputes, not using the public court system. This falls under the umbrella of alternative dispute resolution, or ADR. There are two primary forms of ADR that we're going to discuss in this class, and that is mediation and arbitration. Now, as we mentioned in the previous lecture, disputes often arise in business. And we learned in the last lecture that resolving disputes using the court system can be expensive and time-consuming, and that parties may wish to use private means of resolving disputes. These alternative dispute resolution methods can permit a cost-effective resolution of the dispute, a resolution that will benefit both the plaintiff and the defendant. So in this lecture, we're going to examine alternative dispute resolution methods. Now, alternative dispute resolution, or ADR, refers to a collection of non-judicial methods to resolve disputes, resolving disputes outside of the court system. And why do we do that? Because as we discussed, litigation is expensive. It's costly. A party cannot simply do litigation on their own. They need attorneys, they need lawyers, and when the other side has lawyers, then you need more lawyers, and it becomes a very expensive proposition. And it's time-consuming. A litigation of even the simplest of disputes could easily take 2 to 3 years, and then you're looking at the potential of an appeal past that time. So litigation is extremely costly, not just in terms of money, but in terms of time. And then there's the biggest problem of all, is that litigation produces uncertain results, meaning you are never quite sure what a jury is going to do or to say. When I was practicing, I was fortunate enough to be involved in a number of jury trials. And from my perspective, juries got it right about half the time. So in essence, you could flip a coin or you could have a jury trial. So these uncertain results tend to lead companies into making plans for an alternative means of dispute resolution. Now, increasingly, within the last 20 years, business disputes have been decided outside of the court system, using mediation and arbitration. Historically, of course, court disputes were always heard in the judicial system, using the courts. But beginning in the 1990s, more and more disputes were shifted into private processes. Now, given the risks of litigation, some businesses choose ADR over litigation. And there are a number of reasons why. Starting with cost. ADR could cost potentially a fraction of normal litigation cost. ADR saves money. Mediation can be held within a few days, meaning there's much less time going to be entered by attorneys. It's going to save time and money. It can help to preserve a business relationship. ADR is less adversarial than litigation. So one may see the ability to remain in a business relationship with a company when you have utilized ADR to resolve the dispute. The time spent in ADR is much less. Both mediation and arbitration are much shorter would take a much shorter period of time than litigation would. Expertise. You can draw on the expertise of an industry expert. Mediators and arbitrators tend to be very knowledgeable in a specific field. So if your dispute arises out of a construction defect claim, for instance, one can turn to an arbitrator who is familiar with construction defects, who has seen this type of litigation before, and who has seen what courts routinely do with these types of claims. And finally, privacy. There's generally no public record of ADR, unlike most court cases. So there is no public record available. The parties are able to keep the dispute confidential between them. Now, there are different forms of alternative dispute resolution. The first being negotiation. Negotiation is the simplest and the least expensive alternative to litigation, and something that you should not simply neglect without thinking more about it. Negotiation can be a very cost-effective means of resolving a dispute. Arbitration, which is a formal procedure somewhat similar to litigation, but in a much more relaxed and in a much more compressed time period. Now, arbitration will bind the parties to the result. So one of the key things you have to be aware of with regard to arbitration is that it is binding. The parties are going to be bound by the result of what the arbitrator says. There is no appeal of an arbitration award, ordinarily. Finally, mediation. Mediation is an informal, non-binding procedure. It's really more of an assisted negotiation, a third-party assisted negotiation. Now, we'll talk more about each of these in turn and discuss their advantages and disadvantages. Starting with negotiation. Negotiation has advantages and disadvantages. The parties can negotiate a resolution for themselves without using any third party. And the advantages of negotiation are extensive. It's very inexpensive. Send an email, pick up the phone, send a text message. Very inexpensive. And it's completely confidential. The only parties who know anything about the dispute are the parties involved in the dispute. So completely confidential. It is time-saving. I could pick up the phone today and resolve a dispute by the morning. So time-saving. Another positive aspect of negotiation is the parties are already familiar with the issues and the facts. There is no education needed of a third party of what the dispute is about. So negotiation has a number of advantages, and you may wonder, well, why don't we always use negotiation? Well, there are disadvantages as well. First of all, in a negotiation, parties can often become locked into their position. Why? Because offering compromise could signal weakness. They could be interpreted as a weakness of conviction. You don't believe in your case because you are willing to accept less money than what you earlier demanded. Or you don't believe in your case because you are willing to pay money when before you refused to pay anything. And so what happens in negotiations is that the parties often reach a stalemate because they have become locked into their positions and they cannot see a position different than theirs. And that's the final disadvantage, is this idea that it's difficult to comprehend other people's problems. You understand your problems. It's very difficult to understand what the other side's issues are without a third party to push you closer to a resolution. And that's why negotiation, although it offers numerous advantages, may not be the best means of resolving a dispute. Now, mediation uses a neutral third party to resolve disputes in an informal procedure. Mediation is designed to facilitate an early resolution of the dispute. Now, most mediations take place within the context of the court system. When you file a lawsuit, it is almost certain that before you get fully engaged with that lawsuit, before serious money is spent, the parties will seek a mediation. And if the parties don't voluntarily agree to a mediation, the court will order the parties to a mediation. So I would say that today, virtually all disputes, certainly those filed in the court system, will eventually be mediated. Now, if the mediation is not successful, then you can revert to the litigation that was originally in place. But generally, all disputes are mediated. And if it's resolved, all the better. Sometimes an agreement, a contract, for instance, may provide for mediation of disputes. Courts will almost always order a dispute to mediation before trial. Courts do not like trials. They take up time. They cause the court to fall behind on other issues. And so if the court can refer the parties to mediation and have them work it out themselves, every court is going to like that. The judge's number one priority is always moving the docket, keeping their docket moving. And if I can refer a case to mediation and have the mediator handle it and the parties reach an agreement, that is very good. So mediation has advantages. First of all, it's private, it's confidential, it's inexpensive. Most mediations are resolved within a day, sometimes half a day. And in a mediation, one of the huge advantages of mediation is the parties control their fate. This is the last time in the dispute, if the parties have started by litigating it. The mediation is really the last moment in which the parties can control their outcome. Now, we said most civil litigation is about money, which means that when the parties go to a mediation, they generally will have some monetary figure in mind. The plaintiff knows that it will accept anything above a certain amount. The defendant knows that it will pay anything below a certain amount. So the parties have a fixed number in their mind when they come into a mediation. And if during the course of the mediation, the other party offers a settlement that is better than your number, meaning more if you're a plaintiff or less if you're a defendant, then you can take that. You don't have to rely on the uncertainties of a bench trial, and certainly not the uncertainties of a jury. Furthermore, a mediation agreement, once it's reached, can be enforced in court. So if you reach a mediation agreement and someone breaches the mediation agreement, you don't have to go back and revisit the substance of the original lawsuit. You can simply bring a cause of action based on failure to comply with the mediation agreement. But there are disadvantages to mediation as well. First of all, and maybe the biggest disadvantage, is that mediation relies on each party having a good faith desire to settle the case. If the parties don't want to settle the case, then inevitably the case won't settle. And so when we go to mediation, we must have in our mind a willingness to settle. And one of the reasons why mediation has not been more successful is that for many parties, they use mediation essentially as a form of discovery, to discover what you are willing to offer on a case, but without having any intent on your part to accept that. Another disadvantage to mediation is there's no discovery available. So in order to get discovery, you have to go through the litigation procedure and therefore spend all that money, and at that point you may believe that mediation's not worth it. And finally, if you do reach a mediation agreement and one of the party breaches it, you still have to turn to the court to enforce that mediation agreement. And then from a big perspective, a broader perspective, a meta perspective, one of the problems with all ADR in general, including mediation, is that if the parties are involved in this confidential process and the results of the arbitration or the results of the mediation are never made known because of confidentiality agreements, then it prevents the common law from growing and developing. Remember, the common law is based on precedent, and when a case is decided, it gives guidance to other courts on how to resolve similar case. Well, with a mediation or with arbitration, that information is kept locked within that original tribunal. Let's talk about arbitration. Arbitration is a formal means of alternative dispute resolution. It's a technique for the resolution of disputes outside of the court system. Now, the parties to a dispute will refer it to arbitration by one or more persons, usually called arbitrators, or an arbitration panel. Oftentimes, we will use one arbitrator. Other times, we will rely on 3 arbitrators. And it's very common for the parties to enter into an agreement wherein one party nominates an arbitrator, the other party nominates an arbitrator, and then those 2 arbitrators will pick the 3rd arbitrator. So with an arbitration panel, we know that there is going to be a majority decision. Now, in an arbitration, this third party, whether it's an arbitrator or a group of arbitrators, will review the evidence of the case, and they're going to impose a decision that is legally binding on both sides and is enforceable in the courts. If the parties agree to arbitration, they must arbitrate, and they must accept the results of the arbitration. Now, there are very limited rights of review and appeal of arbitration awards. Generally, no appeal is available outside of a few instances where you are looking at something like fraud on the part of the arbitrator. You cannot appeal an arbitration simply because you believe the arbitrator got it wrong. There is no appeal of an arbitration award. And arbitration is binding in 2 ways. First of all, if the parties have agreed to arbitrate, they must arbitrate. And once they have arbitrated and an award is issued by the arbitration panel, then that award is binding. You must pay. If you then try to relitigate the case, you go file a lawsuit in court, the court will not listen to your appeal. Now, arbitration is widely used in the United States in a number of different aspects. Things like consumer transactions. If you have ever clicked on an iTunes end-user license agreement, if you have an Xbox account or a PlayStation account, if you have a credit card, if you have a cellular telephone agreement, it is almost certain that you have agreed to arbitrate any claims arising out of those situations. Arbitration has become more widely used in employment situations, wherein when you sign your employment agreement, you may agree that you will arbitrate any dispute arising out of that employment, even if the dispute is not based on a contractual dispute, but on something like discrimination. Civil rights cases are often subject to arbitration. Now, arbitration, the rules of arbitration are set forth in statutes, and the most important of these is the Federal Arbitration Act. The Federal Arbitration Act applies to most arbitrations. The Federal Arbitration Act was passed by Congress a number of years ago, in large part because courts historically did not like arbitration. The question is, why are you taking this dispute outside of the court system? What are you trying to hide? And so courts were oftentimes not willing to enforce arbitration awards or require parties to arbitrate. The Federal Arbitration Act stated that it is the policy of the United States that arbitration is a good thing, and if parties agree to arbitrate, they must arbitrate. Now, every state also has an applicable arbitration act, but if there is any conflict between the state act and the federal act will apply. So if the state act provides for limited appeal of an arbitration award, that violates the FAA, the federal act, and therefore the state act in that situation must yield to the federal act. Now, arbitration resembles a court case. The arbitration proceeding is adversarial. And at an arbitration, just as in court, the parties present evidence and witnesses. Now, the rules of evidence don't usually apply because the rules of evidence are about excluding things that may unduly sway juries. But in the case of an arbitration, the arbitrator, the arbitration panel, they are experts. And so they can decide for themselves what is important and what is not, what is relevant evidence and what is not. And once again, let me reinforce, arbitration is binding. The arbitration is going to be conducted in front of a neutral third party or parties, and there's no appeal even if the parties have agreed to an appeal. In this case, Hall Street Associates versus Mattel, this was a case that arose out of a dispute over a real estate contract. And in this case, the parties had agreed to arbitration in their original contract, but they had also had a provision that essentially said if either party is dissatisfied with the arbitration result, they could appeal the award to a United States District Court. So in the arbitration agreement itself, they agreed that one could still file a lawsuit. Now, this case went all the way to the Supreme Court. And at the Supreme Court level, the court said no, that if you've agreed to arbitrate, you must arbitrate, and there is no appeal. The U.S. Supreme Court did not want the United States District Courts to become appellate courts for arbitration. And so even if the parties agree to arbitration, they must arbitrate. Or even if the parties agree to an appeal, they must arbitrate. Keep that in mind for your test. I'm sure there will be a problem similar to that. Just remember that there is no appeal, even if the parties agree to an appeal. Now, arbitration has its advantages and disadvantages, just as with the others. There are a number of advantages to arbitration. It's, again, relatively low cost, especially compared to litigation. It's quick. It's not as fast as mediation, but it's much faster than litigation. That an arbitration proceeding could be decided within a month or two after the dispute is first recognized or claim is filed. You may not even need an attorney. Arbitrations are set up in some certain cases where you just fill out a form and the arbitrator will listen to your case. It's generally easily accessible. Again, if you ever get into a dispute with your credit card company or your cell phone company, the means of accessing the arbitration process are going to be pretty straightforward. And again, you have this advantage of expertise. The arbitrator is familiar with the context of the dispute. There's a lot more certainty because there is no jury. Without a jury, there's much less chance that you're going to receive that there's going to be a wild, crazy award issued, whether that means way too much money or way too little money. There's a lot of certainty involved in arbitration. One of the big advantages of arbitration that people don't focus on, but which I have always thought is important, is that in an arbitration, you are guaranteed the right to tell the arbitrator your side of the story. You get to tell your side of the story. In litigation, as we discussed, oftentimes litigation ends before you ever go to trial, before you ever have a chance to talk to the judge or to the jury. A motion for summary judgment ends a case prior to all of that. Well, in an arbitration, you have the chance to tell your side of the story. And once again, it is confidential. If you do not wish to have your dispute become a public record, you can do that. And then there is a lot of advantages to finality. We mentioned earlier that one of the reasons that businesses do ADR is the idea they want to keep the business relationship going. And so with an arbitration, once the award is made, the dispute is over. The parties can go back to being where they were before the dispute arose. There's no long and involved litigation process and a long and involved appeals process. Instead, it's over when it's over. Now, there are disadvantages to arbitration, one of which is the lack of a public forum. That you don't get your day in court, so to say, because there is no public forum available. The public is not going to hear or learn anything about your dispute. One of the problems, and especially we see this in employment, is the arbitrator can be a repeat visitor. When a business uses one certain arbitrator over and over and over, that business may have an ongoing relationship with that arbitrator. That arbitrator is likely to see the plaintiff only one time. And so you have this repeat visitor problem wherein the arbitrator is getting paid by the business, and therefore they will tend to be, there's the accusation that they could be favorable to the defendant. Arbitration also allows for unfair procedures to be put into place, that because arbitration is binding, the parties can agree to procedures, and if one of the parties is not sufficiently knowledgeable about those procedures, unfair procedures could be put into place. No appeal. Once it's final, it's final. You don't get a second chance to prove your case or to prove why it is that you shouldn't be liable. Plaintiff attorneys can file mass arbitration claims. This has been a real problem in employment disputes, wherein if a party has signed an arbitration agreement, the plaintiff attorney can go sign up multiple employees who may have had the same dispute but don't realize it, and then arbitration suddenly becomes a massive expense. Rather than one arbitration proceeding, you're having to deal with 1,500 proceedings. So that's definitely a disadvantage. And then once again, as with mediation, it prevents the growth of the common law. That when cases are decided in arbitration, those results are not public, they do not set precedent, and no one else can take advantage of what lessons were learned in that arbitration. So in conclusion, what did we learn in this lecture? Negotiation provides the most inexpensive and efficient means of dispute resolution. Mediation uses a neutral third party to resolve disputes in an informal procedure. Remember, it is essentially an assisted negotiation. And arbitration is a formal means of alternate dispute resolution that binds the parties to the result. That's it for this one. Thanks a lot for listening. If you have any questions, please let me know. Thanks again.